Good afternoon. I'd like to call the Subcommittee on Government Operations to order. Today we're conducting a hearing entitled Oversight of the SIGTARP Report on the Treasury's Role in the Delphi Pension Bailout. Given a few minutes for the minority to appear, but I want to go ahead with the proceedings. It appears that there will be votes, and they will probably be the last votes of the day, beginning at a little after 2 o'clock. So we want to try to get through at least part of the witnesses and opening statements, but welcome everyone today. I guess I can't start without remembering that today is September 11th. We did a memorial small service on the steps of the Capitol and remembered those who lost their lives and others on the day that any of us were alive and have a memory we'll never forget. So I, too, remember them. I'll remember, too, Barbara Olson, who was killed on the plane that crashed into the Pentagon, who worked for this committee, a wonderful young professional. We've lost her and lost a number of staffers. Neil Levin, who worked with Senator D'Amato, who was head of the New York Port Authority. I left him in a room in the World Trade Center in a hearing I conducted there about a month before September 11th, and he and everyone who helped us during our hearing, none of them survived except for one. And then remember Terry Lynch, who was an aide to Senator Shelby, was in the Pentagon. I left the Pentagon from Secretary of Defense office September 11th with a breakfast meeting there just a few minutes before he and others were killed, Terry Lynch. So we remember him today, and others that we lost on that fateful day. So remember him. And then members of the Florida delegation also mourn today the loss of our recent member of the delegation, E. Clay Shaw, who passed away last night. So a day that we do remember both former member and the tragic events of September 11th. In just a minute, I'll yield to the minority, but want to again welcome everyone. Today, we're conducting the business of the people, and part of the responsibility of this subcommittee and our committee is to look at various operations and make certain of government, federal government, make certain that Americans see that their taxpayer dollars are properly spent, that we conduct thorough oversight of the legislative and executive process as we intended, as we passed, and as things are executed. So that's an important responsibility that we share today in this committee and part of our business here. The order of business will be opening statements. I'll give mine. We'll recognize other members as they appear. And we may be joined with some Ohio members. I think we have. And I would like to ask unanimous consent that our colleague from Indiana, Ms. Brooks, be allowed to participate in today's hearing without objection. So ordered. So we have one member from Indiana, and I think we may have some from Ohio joining us too, who have interest in this hearing. So with that, then we will recognize our panel of witnesses, hear from all of them, and then we will move to questions. So I'll start with my opening statement. Again, welcome. Today's hearing concerns a very important issue that this committee has been working on for over 3 years. In June of this year, our subcommittee convened a hearing in Dayton, Ohio, area hard hit by the substantial losses of pensions to Delphi retirees. At that hearing, we heard from retirees who are unfortunately feeling the pain of some of the Obama administration's decision to pick very distinct winners and losers in the context of the GM bailout. As part of that, unionized Delphi retirees were made whole because they just happened to be a politically favored group, and unfortunately, the salaried, non-unionized pensioners were left out in the cold. This is somewhat sad because we use Federal money to which all these folks had contributed in their tax dollars to bail out these activities, and some were treated, again, we believe very unfairly. In fact, some 23,000, I think Mr. Turner has a great number in his district, and others that are affected. In addition to the financial hardship, non-unionized Delphi retirees feel betrayed by their government and also by their former employer. While the unions, we find out from a Special Investigator General report, the unions, we find out, were pretty heavily involved in the negotiations surrounding the GI and Delphi bailout. The salaried employees did not have a seat at the table and unfortunately were left in the dark. This whole mess could have been avoided were GM to pursue a traditional bankruptcy route and not be subject to the political whims of the administration. A traditional bankruptcy route would have been better for GM in the long run and would have mitigated the risk of politicized decision-making, such as what not just our committee found, but also confirmed now by the Special IG report that verifies the way this was conducted and how the Delphi salaried retirees' pensions were affected. The bankruptcy proceedings that occurred were simply a legal vehicle for delivering ownership shares in the auto companies to the government. In the words of one legal scholar, instead of a traditional bankruptcy, the quote, let me quote that scholar, said, "The Obama administration, working with the automakers, patched together a process without precedent, a bankruptcy combined without a bailout, incorporating the worst elements of both." The recent release of an audit by the Special Inspector General for the Troubled Asset Relief Program shed light on the facts and circumstances surrounding this decision. We know that despite the Treasury's pledge not to be involved in the day-to-day operations of GM, that in fact Treasury and the Auto Task Force played a major role in the decisions concerning GM operations. As you may know, or just for the record, we tried for several years to get data and information which was withheld from this committee. I'm pleased that we've had the cooperation both of the Pension Guarantee Fund and now supplying the committee information we requested that was denied. And also we've gotten information from Treasury and others that I demanded that this committee have, and I appreciate now the compliance that it's 2 years overdue. Finally, from the report, and this is not my opinion, this is the Inspector General, Special Inspector General said, and let me quote, that despite the assurances that Treasury's role, as well as the Presidential Task Force for the auto industry, was purely advisory, and this is what SIGTARP found, the 4 Treasury auto teams, and again, quote, played a direct role in GM's decisions and operations up to and through bankruptcy, including replacing the then Chief Executive Officer with Treasury's choice. So it shows a story a little bit different than we've been told and confirms, unfortunately, some of our worst suspicions. Today we'll hear from key members of the President's Automotive Task Force about the decisions they made, what took place, how those decisions led to, unfortunately, some very gross inequity between certain classes of employees, some with unions and some non-unionized Delphi employees. We'll also hear from SIGTARP and the Inspector General, Special Inspector General, and GAO, both of whom conducted thorough audits relating to this issue. Lastly, I can't help but thank Mr. Turner of this panel for his unyielding dedication, determination to get to the bottom of these issues. With his assistance, we're getting more of a complete picture and the information we requested and the taxpayers deserved and what took place in this whole process. Mr. Turner has tirelessly pursued justice in the area. It represents many of the folks who were affected. And our committee is, in fact, committed to finding out exactly what happened, when, who was involved, why, and particularly why there was unfair treatment with taxpayer dollars for some, and again, the unfairness of the whole process. If these decisions were made on the basis of politics and not prudence, those responsible need to be held accountable for their actions. I'm now very pleased to recognize the distinguished ranking member, the gentleman from Virginia, Mr. Conley, for an opening statement.
Mr. Chairman, I do have an opening statement, and I thank you, but I was running a little bit late, and out of a courtesy, if the ranking member of the full committee wishes to go, I would defer to him. And then
Mr. Cummings then is recognized.
Thank
you very much, Mr. Chairman. I want to thank the ranking member for his courtesy. Mr. Chairman, I want to thank you for convening what common sense would suggest will be the capstone on this committee's 5-hearing inquiry into GM's decision-making on Delphi pensions during the extraordinarily successful rescue of the United States automotive industry. In 2009, the administration's auto team members came from the private sector, took up the mantle of public service, and assumed responsibility of managing the investments that the Bush and Obama administrations made to save the United States auto industry from collapse. Thanks to their work, America's automotive industry today directly employs 1.7 million people, and indirectly, this industry accounts for roughly 8 million jobs nationwide. That represents 4.5% of all private sector employment. It also accounts for roughly $500 billion in wages being paid to workers and $70 billion in personal income tax revenue. I thank the former auto team officials for their work to protect this industry and the American economy. You did a critical job, and you did it exceedingly well. It is unfortunate that regardless of these impressive results, Republicans continue to criticize the successful rescue of the American auto industry. The majority, including members of this committee, has perpetuated the narrative that government officials made the decision that the salary retirees of Delphi would not get top-ups. We know now that that narrative is inaccurate. SIGTARP's report makes clear that a high-ranking GM official made that decision, not the administration. SIGTARP also found that at the time of Delphi's spinoff from GM in 1999, the pensions of Delphi's salary workers were fully funded. That is why the high-ranking GM official believed that giving the salary workers a top-up in 2009 would have been tantamount to paying that group of workers twice. SIGTARP also found that the unionized workforce did not receive fully funded pensions when Delphi was spun off. To the contrary, their pensions were underfunded, but their union negotiated contracts with GM to top up their pensions in the future. And when the union insisted that those contracts be honored in the bankruptcy process, they were honored without question. SIGTARP found that, quote, no person SIGTARP interviewed could recall any discussion of the top-up agreement at the negotiations, end of quote. The facts found by SIGTARP are consistent with GAO's review, completed more than a year and a half ago. GAO detailed the business reasons for GM to honor previous agreements with certain unions. A failure to honor those agreements would have jeopardized the company's ability to move forward. I feel bad for the Delphi employees who did not receive top-ups. There will be hard days ahead for them. They were betrayed by Delphi's management, which did not make pension payments for years after spinoff. But none of that is the fault of the government's effort to save GM. The investigation into this matter has been thorough. As an investigative body, it is critically important that we follow the facts wherever they lead. And it is equally important that when we get answers, we accept those answers. We now have the facts. We now have the answers. And I ask that the majority accept them, and with that, Mr. Chairman, I yield back.
Thank the gentleman. Yield now to the gentleman from Ohio, Mr. Turner.
Thank you, Mr. Chairman. I'm just astonished, and I'm sorry, Mr. Cummings, I usually don't respond directly to what someone else is saying in their opening statement, but all of that has absolutely nothing to do with this hearing whatsoever, and I hope that you actually sit down and read this report. There is nothing in this report that says that they were not involved in the PBG's decision-making with respect to Delphi and salary retirees. In fact, this report is about the hourly, not the salaried. And you're going to see that when we have this discussion. In fact, it does say on the hourly the opposite of what you just said. Again, if you'd read the report, page 38 says, I'm going to quote it, "The auto team's role in the decision to top up the pensions of Delphi's UAW's workers was not advisory. Consistent with the auto team's practices with any liability, it would have been Treasury's decision as the buyer to assume or reject the liability to top up the pensions of Delphi hourly UAW employees. The auto team actively negotiated and made the overall deal." Now, there is partisan politics that shouldn't be happening here in this hearing, and the GAO report it was not as extensive as this SIGTARP report has been. And I want to thank Ms. Romero. Thank you for your in-depth review. This is the first time we've ever really had an insight into what the Auto Task Force did. And I must tell you, it's just shocking, because remember, the last hearing that we had, Mr. Cummings, the last hearing we had to have it because these gentlemen refused to even talk to the Inspector General. They said we'd left the government, we no longer have to answer questions on the work that we did. We've had to subpoena Treasury just get to the bottom of what happened in these things. So now I want to give some context of what we're doing here today, because this really, really is important. And this is the fact that in the TARP process, what occurred was not just the tragedy of the Delphi and salary retirees getting their pensions cut unjustly and I believe illegally, and the courts will determine that, but what we had was the entire process was thwarted. Because of TARP, normally when you have a bankruptcy, each of the parties who have an interest in either the new entity that's coming out or the old entity that is going through the bankruptcy process sits in a chair and represents their interests, or they have someone who sits there in a fiduciary capacity representing their interest. But what we had with TARP was this perversion of the process where each and every person sitting around the table suddenly became the Treasury Department. The banks became the Treasury Department, the lien holders became and bondholders, the PBGC became the Treasury Department. Each and every one of these people became the Treasury Department. And what we kept saying throughout all of this, which is why we're having this hearing today, is tell us how you made your decisions. Tell us, once you had all of these chairs, whether or not you go to the standard of protecting the fiduciary interests of the people who were behind you, because we don't believe that you did. What we find now from the SIGTARP report, which is the first time we've ever had any insight into what occurred in the decision-making, we understand that they set this unnecessary and artificial timeline of the quick wash, that they set the terms and the conditions, they determined who had leverage and who did not, some political, some not. And it clearly, throughout all of this, is this concept of exceeding and abusing authority, this concept of commercial reasonableness that this group used to as a standard for determining their decision-making that had no definition and no legal justification, had people rewarded and people who were penalized. The administration picked winners and losers, and that's what this report says. And that's what we're going to get to today. Now, this does not decide the issue of PBGC and the Delphi salary retirees. It was not intended to. This hearing is not to determine the end of the PBGC issue and GM issue with respect to the Delphi salary retirees. That we will have to continue. GAO, when they did their report, only looked at public sources. They didn't have access to what the Inspector General did, where they looked at the documents and looked at the emails between these individuals. And the SIGTARP Inspector General did not check or review the GAO work to determine whether or not additional documents were necessary or whether or not the documents that they had needed to have the GAO report amended or redone. But it tells us what we didn't see before. The administration has said they were not involved. They said they didn't do it, that they only were on the sidecar and watched as General Motors made the decisions. And what we know now from this report is the decision-making was absolutely being made by the auto task force individuals themselves. That they were, the 4 Treasury auto team officials played a direct role in GM's decisions and obligations up to and through GM's bankruptcy. Treasury's auto team had significant leverage and influence on GM's decisions leading up to and through the bankruptcy, first exerted by replacing the GM chief executive. So if the document itself is allowed to go through this hearing, instead of us just reading our own text that our staffs have written, I think we'll get to what really is the truth. What really happened, what needs to happen, was there injustice, and what this committee needs to do in further investigation, because this is not over. Thank you, Mr. Chairman.
Thank the gentleman. Mr. Conley.
Thank you, Mr. Chairman, and thank you for holding this hearing. Let me just say, as a member of this committee, I would caution my colleague as to characterizations about what homework is done or what reading is done or not done by the distinguished ranking member of this committee. I've known Mr. Cummings a long time. He does his homework. To suggest that his opinion is wrong because he didn't read the report, I think crosses the line. If you want to disagree, disagree. But to impugn the reputation of the distinguished ranking member as somebody who comes here unprepared, I take exception to on his behalf and on behalf of this side of the aisle. And I urge my friend from Ohio to restrain from such characterizations. Mr. Chairman, SIGTARP's report directly and definitively refutes the narrative we've just heard on this subject. And we just heard, for example, that this report didn't really address certain subjects. And I put up this slide on page 29. It most certainly does. It most certainly does talk about the salary plan and explains what happened, at least from somebody's point of view, SIGTARP's, why they didn't top off the non-union salaried retired pensions after the 1999 separation. This committee has explored in great depth the Federal Government's unprecedented intervention that not only rescued our nation's auto industry, but enhanced the global competitiveness of the auto sector. Hopefully, with the issuance of SIGTARP's report and today's hearing, we can finally put to rest the unsubstantiated conspiracy theories about picking winners and losers to benefit political allies. Unfortunately, some refuse to acknowledge the sheer complexity of the challenge then facing the administration in assisting General Motors navigate what SIGTARP characterized as, quote, one of the largest and fastest bankruptcies in the nation's history. It's easy to discount the monumental achievement in light of current auto industry conditions. Consider, just 2 years ago, GM sold more than 9 million vehicles on its way to posting a record-breaking profit of $7.6 billion, a company on the ropes that was looking at liquidation in 2009. Just last month, GM posted its best month ever since the Great Recession. We must not forget the perilous days of late 2008 when leading economic think tanks were projecting the bankruptcy of all U.S. automotive manufacturing, and that would trigger a collapse of the domestic auto industry, costing us an additional 3 million jobs, while we were shedding 750 a month. Indeed, 750,000. Indeed, it was estimated just the liquidation of GM alone would lose 900,000 industry jobs. And of course, SIGTARP found, and I quote, ultimately GM did not fail, and the broader systemic consequences of a GM failure the Treasury had feared were avoided, unquote. Yet, the majority narrative continues to appear disinterested in convening a hearing to examine the lessons learned from all of that and from the effective Federal initiative to save the U.S. auto industry. Instead, we find ourselves holding what is now the 5th hearing to rehash some hackneyed assertions from the past. Of course, a thorough review of SIGTARP's report enables one to test, and I think ultimately rebunk, those unsubstantiated claims. For example, did the administration inappropriately intervene in the decision to deny Delphi salaried workforce top-ups as part of the nefarious scheme to use GM's bankruptcy proceedings as a cover to protect political allies? No. As SIGTARP itself reports, there was no impropriety, and it was a sound business decision from a substantial point of view for GM to deny pension top-ups to certain Delphi employees. According to SIGTARP, more than a decade ago, Delphi's salaried workers received full funding of their pensions when the firm was spun off from GM, while the unionized workforce did not. Instead, in exchange for underfunding union pensions in the spinoff, labor negotiated contractual agreements with GM, legally binding contracts to protect the pensions of certain unionized Delphi hourly employees, not in the context of TARP, but 9 years earlier than that. This strategic decision paid off when the financial crisis hit and Delphi's unionized workforce emerged with its pensions protected. Regrettably, Delphi's salaried workforce had not negotiated similar contracts. And when GM entered bankruptcy, the firm had no contractual obligations to top off their pensions. As SIGTARP noted, a hypothetical GM decision to top off those pensions, a cohort that no longer worked for nor had any association with GM by the time of TARP, would be equivalent to GM paying for the Delphi salaried pensions twice from their point of view. The bottom line is that GM's refusal to top off the pensions was a business decision, not a government policy decision, nor was GM in a position before a bankruptcy judge to undertake a new financial obligation while it's trying to go through bankruptcy. In a perfect world, perhaps, GM would have prioritized fairness over commercial interests and treated the pensions of all of its former employees at Delphi equally. But bankruptcy is not a perfect world. It's an unfair and staggeringly difficult battle for survival itself. And I believe the record presented by SIGTARP and the witnesses before us today clearly demonstrates that GM, supported by Treasury and the Auto Task Force, made those tough decisions under tremendous pressure, but not political pressure. Thank you, Mr. Chairman.
I thank the gentleman. Mr. Amash, did you have an opening statement? Mr. Pocan?
Mr. Chairman, could I ask unanimous consent to allow our colleague, Mr. Tim Ryan of Ohio, to participate?
And what I'm going to do then is we've had Ms. Brooks, who's not a member of the panel, and we approved her. I have your request for Mr. Ryan, a gentleman from Ohio, and then we have a request from Mr. T. Berry, also a gentleman from Ohio. I ask unanimous consent that both of these colleagues be allowed to participate in today's hearing without objection, so ordered.
Thank you, Mr.
And our usual rule and procedure for those who have joined us would be we'll recognize the members of the panel first, and then we'll go to you. I think what we're going to do, though, is if we have no further opening statements, is go right to our panel of witnesses. We are expecting votes shortly, as I said. So, with that, let me introduce our panel of witnesses. We have the Honorable Christy Romero. Before I do that, let me say that without objection, the record will also be open for additional statements to appear in the record at this point and throughout the proceedings, to be fair to everyone who's now participating. Again, the panel of witnesses, Honorable Christy Romero is the Special Inspector General for the Troubled Asset Relief Program. Ms. A. Nicole Clowers is Director of the Financial Markets and Community Investments at the United States Government Accountability Office. Ms. Barbara Boberg is Managing Director of Education Workforce and Income Security Issues at the Government Accountability Office. Mr. Matthew Feldman is a partner at the law firm of Wilkie, Farr and Gallagher, and he served as legal advisor to the Treasury Auto Team. Mr. Stephen Ratner is the chairman of Willett Advisors and served as the head of the Treasury Auto Team. And then we have Mr. Harry Wilson. Harry J. Wilson is the chairman, CEO, and founder of the, what is that, MAVA Group, and served as a member of the Treasury Auto Team. And finally, Mr. Harvey Miller is a partner at the law firm of Wheel, Gotzel, Manges, okay, and no special promotions there. Manges then served as lead counsel in the General Motors bankruptcy case and was the vice chairman and managing director of Greenhill and Company. So I welcome all of our witnesses. Let me say that this is an investigative panel, and it is our procedure to swear in all of our witnesses. So if you will stand now, all the witnesses, raise your right hand. Do you solemnly swear or affirm that the testimony you are about to give before this subcommittee of Congress is the whole truth and nothing but the truth? All of the witnesses, the record will reflect, answered in the affirmative. Thank you. And let me just give you the ground rules here, too. We give you 5 minutes. If you have a lengthy statement, information you'd like included in the record just through the chair or member, you can ask consent, and we'll include all of that in the record. So I'd like you to summarize, try to keep it to 5. We'll also go through the entire panel and then go to questions. We're going to try to get to as many as we can of you with a 5-minute. Then we'll probably have to recess for, and the staff will tell us the amount of time the votes are. There's actually only 1 vote, so we'll only recess for about 15 minutes. I'll give you a chance to scoot out, but be back. And then we will proceed immediately until we have heard from all of you. Then we will begin the questioning. So that's the order of business. So again, thank you. Let me turn to our first witness, which is Christy Romero, and she is the Special Inspector General for the Troubled Asset Relief Program. Thank you for your work, and we recognize you now for your testimony.
Chairman Mica, Ranking Member Conley, and members of the committee, it's my honor to appear before you today. SIGTARP was created by Congress to conduct investigations and audits related to the TARP bailout. In our investigations, we are a law enforcement agency, and we have authority to search, seize, and arrest. So far, 151 people have been charged with crimes as a result of a SIGTARP investigation. 111 of them have been convicted so far, while others await trial or guilty plea. And of those that are convicted, so far 58 have been sentenced to prison, while others await sentencing. And the average prison sentence for a SIGTARP investigated crime is 68 months, which is nearly double the national average for white-collar crime. We also conduct audits of decisions that were made related to TARP, and we issue these audits not to criticize for criticism's sake, but we issue them to ensure that our government functions at its best. We issue them to bring transparency, and we issue them so that we can learn from the past in case the government faces similar situations and decisions in the future. Our latest audit reviewed Treasury's role in the decision to top up or make whole certain unionized former GM employees who worked at Delphi. And Treasury's public statement that its role in that decision was advisory has caused unnecessary confusion. It's also inconsistent with Treasury's rights under the 2008 TARP loan agreement and as the purchaser of GM in bankruptcy. Under the TARP contract, there are certain big things, like the collective bargaining agreement with the union, where Treasury made the decision. And there's other things where Treasury could only advise GM. The top-up agreement and the collective bargaining agreement are not two separate things. The top-up is in the collective bargaining agreement. The UAW came to the negotiation with Treasury and GM with a priority list that included the top-up. There were no negotiations of the top-up. GM did not come to Treasury later to discuss it. It became a foregone conclusion that it would be included, with Mr. Ratner and Mr. Bloom of the auto team telling us that because it was on the UAW's list, it was clear that the UAW expected it to be part of the deal. As the purchaser, known as New GM, it was Treasury who made the decision on the collective bargaining agreement, because only the purchaser could define the relationship with the union, and only the purchaser could determine which obligations to take on. Both GM officials and auto team officials told us that Treasury was the purchaser who made decisions on which obligations to take on. GM's lawyer, Mr. Miller, testified as to that today. Therefore, the auto team's role could not be advisory. Who would they be advising? It would have been much better if Treasury had been transparent, saying that we made the decision with GM to agree to the top-up because the UAW really wanted it and we are under time pressure. It would have been much better if Treasury had simply stated that we were concerned that in addition to the traditional strike leverage, that UAW had the leverage to prolong the bankruptcy, that they did not think that GM could survive a lengthy bankruptcy and that could hurt the auto industry. They should have explained their decision and trusted the American people to hear their reasoning. American taxpayers can either agree or disagree with what the auto team did, but they are entitled to full transparency, and that's why we put this report out. So what was the alternative? Well, one alternative would have been to actually raise and actually negotiate the top-up with the UAW. But Treasury conditioned the TARP funds on GM finishing the bankruptcy in 40 days, which had never been done, or else they would default. This severely limited the alternatives available to GM. GM's then CEO told us they are under pressure to get the deal done, and that is why the top-up was not negotiated. But we found that the pressure came in part from the 40-day time constraint, a time frame that gave the UAW additional leverage. GM thought 40 days was unrealistic, that they needed 60 to 90 days. No one will ever know if more time in the bankruptcy would have allowed for negotiation of the top-up, but Treasury should take accountability that their 40-day condition had the effect of limiting GM's options. Finally, there is an alternative still available today, which is for GM to consider topping up or contributing to the Delphi salaried retirees today. Thank you again, and I'm happy to answer your questions.
Thank you. And as I said, we'll withhold questions. Now we have two GAO representatives, and we're going to recognize, I guess, Barbara Boberg as the witness from GAO. So welcome, and you're recognized.
Thank you so much, Mr. Chairman, Mr. Conley, members of the committee. Thank you for inviting me and my colleague, Nicole Clowers, here today to speak about the termination of the Delphi pension plans. Our testimony today will address the timeline of key events leading to the plan's termination and the role of Treasury in these activities. This information is drawn from our 2011 reports prepared for Mr. Turner and others and relies on publicly available documents. First, the pension plan terminations. In 1999, the Delphi Corporation, once part of GM, was spun off as an independent company. And as part of that arrangement, GM was required to bargain with the unions affected by the spinoff. In those negotiations, GM agreed to provide top-ups to the unionized employees, meaning that if something went wrong with the pension plans for these employees under Delphi, GM would make good on their promised benefits. At the time of these agreements, Delphi's hourly plan was not fully funded. In contrast, the salaried employees' plan was fully funded. So fast forward to October 2005, when Delphi filed for bankruptcy. All Delphi pension plans were underfunded, and Delphi was not planning to make any contributions to these plans during the bankruptcy process. Hence, the prospects for those plans and for the participants' future benefits got substantially worse. By the fall of 2008, Delphi was still in bankruptcy, and economic conditions had deteriorated throughout the auto industry. GM's losses led the company to seek assistance from the Federal Government. By April 2009, the Department of the Treasury was working with GM to develop a restructuring plan, and by June, GM, too, had filed for bankruptcy. In June, as part of an arrangement for GM to emerge from bankruptcy, GM and the UAW agreed to modify wages, benefits, and work rules to be more cost competitive, and agreed that new GM would assume all employment-related obligations and liabilities for any employee benefit plan covered by collective bargaining agreements. This, in effect, maintained the benefit guarantees GM agreed to in 1999. Meanwhile, Delphi and PBGC began the process of what's called a distressed termination of Delphi pension plans. In accordance with governing statutes, PBGC estimated that Delphi plans were $7 billion underfunded, with PBGC expected to bear $6 billion of that shortfall, and Delphi plan participants the remaining billion. However, per the settlement agreement, GM provided top-up payments to all unionized workers. No such agreement pertained to salaried workers, and this is where the situation stands today. So let me turn to the role of Treasury in these decisions. As GM's primary lender, Treasury played a significant role in helping GM emerge from its bankruptcy, which included resolving the Delphi bankruptcy. However, with regard to GM decisions about the Delphi pension plans, the court filings and statements from GM and Treasury officials that we reviewed suggest that Treasury deferred to GM's business judgment. According to these records and to Treasury officials, Treasury agreed with GM's assessment that the company could not afford the potential costs of sponsoring the entire Delphi hourly plan itself upon emerging from bankruptcy. Treasury also agreed with GM's rationale not to assume the Delphi salaried plan, since that plan had been fully funded when GM transferred it to Delphi in 1999. As for the top-ups, Treasury officials said the Treasury did not explicitly approve or disapprove of GM's proposal to honor previously negotiated top-up agreements with some unions. Treasury stated that its aim was to ensure that the new GM would only assume the liabilities of the old GM that were commercially necessary. Due to new GM's continued dependence on the UAW workforce and the workforce of the other unions, Treasury officials felt GM had solid commercial reasons to agree to the top-up pensions of those retirees. I'd like to conclude with a few thoughts about these pension terminations. Under pension insurance laws, when companies go bankrupt and leave their plans with large unfunded liabilities, some participants may not get the full benefits promised to them by their employer. This, unfortunately, is not unusual. What makes the Delphi terminations different is the linkage to the GM bankruptcy and GM's role as a pension benefit guarantor. Additionally, Treasury's multiple roles in this process, as SIGTARP just noted, have led to concerns about transparency to Congress and to the public. Although Treasury has established policies to separate its multiple interests, we believe the most effective means of addressing concerns about these different roles is for Treasury to be as transparent as possible about its activities. And that concludes our statement, Mr. Chairman. Ms. Clowers and I are happy to answer questions.
Thank you. And as I said, we'll get to questions in a little while after we've heard from the others. Let's see. We have next Mr. Fellman, and Matthew Fellman is a partner in Wilkie, Farr, and Gallagher. Welcome, and you're recognized.
Thank you. Mr. Chairman and members of the committee, I understand that I've been invited to appear before you today to discuss my role with the Treasury Department's audit team, which I joined in March 2009 as legal advisor, and on which I served until August 2009. The Treasury Department recruited me to join the audit team for my career as an attorney in private practice, where I specialize in reorganizing and restructuring large businesses, not unlike the American automobile manufacturers that were in significant financial distress in 2009. I believe that the work of the audit team contributed to a successful effort to avert disastrous consequences to both the American automobile industry and the American economy as a whole. Now, just 4 years after emerging from bankruptcy, both General Motors and Chrysler are selling cars and adding jobs at a pace most thought unachievable. I remain proud of my service, and I am prepared today to assist the committee in reaching a complete understanding of the auto team's work with respect to General Motors, and in particular its relationship with its critical supplier, Delphi Corporation, during what was a difficult time and an unprecedented challenge for all involved. Although it is wonderful to see the dramatic recovery of the automobile manufacturers and the thousands of American jobs that were saved and have been created as a result of our work, I am mindful that the restructurings that the auto team worked on required many Americans to make great personal sacrifices. As a result of the Delphi bankruptcy, for example, Delphi's lenders, some of which had purchased Delphi's debt at a steep discount, exerted significant influence over Delphi and ultimately the PBGC, which forced the PBGC to terminate Delphi's pension plans. As a result of what occurred during the Delphi bankruptcy, there are Delphi retirees who unfortunately will collect less than their full pension benefits. As stated by the Special Inspector General for the Troubled Asset Relief Program in her August 15th report to Treasury Secretary Liu, in 1999, when General Motors spun out Delphi as a separate company, Delphi's pension plan for its salaried employees was significantly overfunded, but the pension plans for hourly workers were significantly underfunded. To garner support and consent from the UAW and other unions for the Delphi spinoff and to avoid having to make a significant payment in 1999, General Motors and the UAW entered into a top-up agreement whereby GM agreed to make whole hourly employees being transferred to Delphi on their pension obligations in the unlikely but ultimately real event that Delphi defaulted on its pension obligations. Following years of mismanagement and malfeasance, Delphi was forced to file for bankruptcy in 2005 after having allowed both its salaried and hourly pension plans to become underfunded, a situation that ultimately led the PBGC to conclude it needed to take action to terminate both plans. As stated by the GAO in its March 30, 2011 report to Congress on the topic, the PBGC reached its own conclusion to terminate the Delphi pension plans, presumably after concluding that this was proper action to take under applicable law and that among the limited options available for these plans, the termination and takeover by the PBGC was the best choice available. While I can understand why all parties involved would have preferred if General Motors had assumed these Delphi pension plans, taking on these liabilities in full would have threatened GM's future success as it exited from its own bankruptcy. While General Motors was not willing to assume all of the pension plans, as the SIGTARP report makes clear, because GM viewed a well-motivated workforce at its own facilities and at its largest supplier as critical to ensuring an uninterrupted supply chain, General Motors made the commercially reasonable and necessary decision to honor its legal obligation memorialized in the top-up agreement with the UAW. The decision to assume the UAW top-up agreement was bargained for by the UAW and agreed to by General Motors after having been extended by the parties once in 2007. As this committee is aware, unfortunately many of Delphi's employees did not have similar top-up agreements with General Motors, and some of the employees will face a shortfall in their pension payments. The auto team agreed that honoring the top-up agreement was a prudent business decision. We believe that doing so would protect both General Motors and the American taxpayers' collective investment in the company. The desire to limit General Motors' stay in bankruptcy was purely economics. Every week of bankruptcy where General Motors continued to carry all of its costs but generated little or no revenue would cost the American taxpayers $1 billion. The need for General Motors to complete a 363 sale in a short time period was intended, among other benefits, to limit the costs being borne by taxpayers. While I am pleased that General Motors and other American automobile manufacturers have become successful, profitable contributors to our economy, I recognize that the restructuring process has resulted in painful but necessary sacrifices on many of Delphi's stakeholders. As a bankruptcy practitioner and restructuring specialist, I have seen similar circumstances all too often. It is without a doubt one of the most difficult, disheartening aspects of my job, and I have only the deepest sympathies for everyone affected. I am here today and prepared to answer any of the questions of the committee.
Well, thank you. We have 4 minutes left before the vote, so what we're going to do is we will recess. Now I'm told there will be 3 votes, so this will be a little bit longer. It usually takes us 15 minutes, another 5 and 5. Probably be back here about 10 minutes of to 10 minutes of to the hour of 3 o'clock, somewhere there. And we will come back. Mr. Ratner, you'll be the first recognized. Mr. Wilson, then Mr. Miller will go through. So you don't want to wander too far off. So with that, we will, the committee stands in recess until after these votes.